an operations position, basically meaning that I have to monitor compliance all the time. So the reason I like doing that is because I feel that most people want to be compliant with treatment. They want to feel confident in what they're doing, but oftentimes we struggle with not just training, but how do you translate training into application, right? So we all go to a boatload of training, but then once you leave, and if there are any managers or supervisors in the audience, how do you then assess whether or not someone has been able to apply or integrate what they've been trained on in their day-to-day practice, right? So I have two things that I'm going to be presenting this afternoon. The first one is on HIPAA and 42 CFR. We're going to do that one first because I know that you guys have consumed a lot of carbs. And then we'll do the second one. On substance abuse and addiction treatment, which is something I'm passionate about, so it's going to be hard for you to fall asleep on it. And then, but before I get started, I was reading some of the job descriptions for the positions that you folks are going to be in, but I wanted to hear from you because it's hard to sometimes understand what that looks like. What do you understand your role to be, and how will this benefit you? So who do we have here? We have care managers, right? Is that what they're called? Yes, no? Care coordinators. So what does a care coordinator, what does it look like? What are you going to be doing? No thoughts? You guys just tired? We're not sure what you're going to be doing? Are you going to be working with people? Okay, great.
I can tell you, I've said it like 3 times, so I was hoping somebody else would go. And
I'm sorry.
No, not towards you. I'm saying I feel like I'm the only one that talks about it. So I was hoping somebody else would.
Well, that means you're excited about your job, so you're ahead of everybody else.
So, as care coordinators, we're coordinating care with the individual and anybody who is working, any of the providers who are working with the individual. So it can be any kind of a state agency.
So just to stop you, but coordination means a lot of things.
Well,
are you coordinating from a phone? Are you with the patient and bringing them?
Well, I was going to touch on that.
Okay. All right, she's going to come up here and do her thing.
So what we're helping them do is, in my opinion, you can transport if you're comfortable with doing so, but in our facility, we're going to try to get them all coordinated with a CSP worker that can help with the transportation part, but we're primarily telephonic. So we'll be contacting, getting them connected with a PCP, finding them specialists, getting them to...
So you won't be working as much directly with them as other folks. You will be more doing work via a phone.
More, absolutely. Well, a little bit of both.
A little bit of both?
Because we're still going to have to meet with them face to face. Right, we're a CSP, seeing them regularly, once a week, once every other week, a couple times a month, that kind of stuff. We're meeting with them when...
Every 90 days, we're supposed to meet them or something?
We have to see them every 90 days. You can see them before then if something comes up, if you want to attend a care plan meeting, or if you want to go to a specialist.
So the minimum requirement would be a face-to-face at least
Quarterly.
once every 3 months.
Quarterly.
And you will also be and other than that, a lot of the work is going to be on a telephone. Is that safe to say? Just so I can kind of understand. So that's one position. Because I thought there were 2 job descriptions or 3.
There's nurses.
Nurses. And what will the nurses be, what's their role in this process?
I can speak.
Wonderful.
I'm glad.
So that medication reconciliation. So I guess when we're supposed to get like what, upward of 3,000 folks to begin with. And they all have to be imputed into this Care Navigator system that was software.
So some data entry?
Yep. And I'm assuming as the nurses, we'll be having caseloads of 250 folks each. And doing med rec for...
That sounds exciting.
Oh, yay. And doing med recs for them. But that's one requirement.
So one requirement is med reconciliation. So all of these folks that you're going to be referred to, part of your job is going to be to reconcile their medication and make sure things are the way they're supposed to
the
be.
PCP and other, we all know they have 1,000,001 providers. So, but if they happen to go in inpatient, we have 3 days to do a face-to-face.
If they go inpatient.
If they go inpatient.
After they've been discharged.
After they're discharged. Did you get it?
After they're
I'm still
discharged
done.
from the inpatient, you have 3 days to do a
3 days.
face-to-face.
Yes,
Interesting,
To make sure their meds are.
to make sure that meds are up to date
interesting.
and reconcile
Okay.
their meds.
So you'll be connecting with them 3 days after they discharge from an inpatient level of care.
Yep,
And you'll be getting that information in terms of where they're located, how.
so now that's gonna be one of the challenges.
One of the challenges, huh? Okay. And so, well, that's good. So you meet with them within 3 days to sort of ensure that whatever they may have been discharged with or whatever that continuum of care, that it gets linked and that happens.
Exactly.
Wonderful. Okay, so that's good. That's definitely a good thing. I could see how we might be able to help in that process. Any other positions that I missed? Nope, those are the two.
They're supervisors.
And the supervisor. Any supervisors here?
Directors too.
Directors? Okay, okay. All right, and my understanding is that there are a few organizations represented, is that correct? Okay, so when it comes to HIPAA and 42 CFR, one of the things that I always tell folks when I'm doing training is know your company's policies. So I can only speak to general practice with HIPAA and 42 CFR. The PowerPoint that I have is geared towards my facility, but you'll get what you need from it in terms of understanding it. But one of the things I tell them all the time, and you'll see in the PowerPoint, I actually list the policies that the staff are responsible for reviewing and making sure they know. Because oftentimes we panic because we're worried that we're going to do something that is going to result in what? A termination. That's really what the biggest fear is. And so because there's this genuine fear of like, oh my God, if I mess this up, I could lose my job, we sometimes in the field of substance abuse actually become unhelpful to the patient. Because HIPAA and 42 CFR in particular, was not made to create a barrier to treatment or continuum of care, or even just for them to be able to advocate for themselves. It was intended to protect them from being stigmatized, have a bias against them. That's really what it was there for. So I'm going to give you an example. I have done a lot of stuff, a lot of different jobs in the last 14, 15 years. I've always had one full-time job, and then I've always had multiple different jobs, like pockets on the side. I like to keep busy. So one of the things that I did for about 7 years was I was an administrator on call and a crisis clinician for New Bedford Child and Family, and I also did a couple of weekend overnights at St. Luke's Hospital. I used to travel from St. Luke's, Toby, and whatnot. And one of the things that I used to find is that when we were trying to place folks, we would fax over our release. Now, mind you, they're in a crisis setting. We would fax over a release, but if you're in an inpatient level of care, you could have the first shift, second shift, you could have that nurse, a different nurse, there could be anyone that answered that phone. And then we would call back to try to secure something. I can't confirm or deny.
Yep.
I can't confirm or deny. It didn't even sound friendly, right? So when you're working with providers, you don't want to come across as though you're not willing to try to find a solution, but you do want to maintain that it's important for you to protect the patient's confidentiality. And there's a way for us to do both, and we're going to talk about that today, okay? And I forgot my little clicky thing, so I have to... All right, so what's on the agenda, which we may or may not cover all of it because some of it's not related to folks, so I'll skip over that portion, but we're going to define HIPAA in 42 CFR Part 2. We're going to talk about disclosures, patient identifying information. What are the exceptions? Policies. So this is where, depending on where you work, you want to find out from your supervisors what the policies are for the company that you work for. So if you work for anybody from High Point, yep, we're from High Point. Hello, High Point. So if you're from High Point, you get a jump start because this is in your PowerPoint and you have the policies that you should be familiar with. So you get a jump start. Patients in their medical records. what do they have a right to, right? So we're going to cover that. Phone calls and visitors. So oftentimes I will address how do you manage getting a phone call from someone that you don't know that's asking about someone that you're working with, right? What are the best way to manage it? When we deal with inpatient, I also talk about visitors and guests, and then social media. This is not being cooperative. Here you are. Okay, so HIPAA. HIPAA stands for Health Insurance Portability and Accountability Act. Establishes safeguards to protect privacy and medical records and other protected health information. And healthcare providers, in particular, transmit health via electronically. So it covers that as well, and also health insurances. The federal law, or 42 CFR Part 2, now are all the folks that you're working with going to have, be coming from a federally funded substance abuse program? Do you folks know if you work for a federally assisted funded program? So 42 CFR applies to those individuals who work in a federally funded substance abuse program.
That's not us,
What's that?
Oh, I was just saying, it's not me.
right? That's not us.
I don't know. I don't know what program you work for.
No, I was just saying.
Oh, okay. But for High Point, you are. So we have to adhere. We have to adhere to 42 CFR. And the reason I specify that is because 42 CFR has more restrictions than HIPAA. HIPAA is a little bit more lenient, and we're going to talk about why that may or may not make it challenging when you're care coordinating. Okay? And I have a handout for you folks. Jessica has it over there, so you don't have to take a gajillion notes, or it was supposed to get handed out. I'll have her hand it out to you, but I do have this for you. So, except under certain specific conditions, the regulations prohibit the disclosure of record or other information concerning any patient in a federally assisted alcohol and drug treatment program. HIPAA is more permissive, and this is where it becomes a challenge. Now, you folks necessarily won't be dealing with DCF or probation, though you might, I don't know, but you might be dealing with a PCP office. Does that sound okay? So help me out, because I'm still piecing together what you guys do. So if you are working with a PCP office, most of the time, though some of them are getting really good, their releases will not have what we need to see on it in order to coordinate care with someone. So on it, there needs to either be a check mark with a clause that talks about including substance abuse information. So sometimes when you go to your PCP, you'll see that they don't necessarily have it outlined as 42 CFR, but they'll have HIV and or related information and you can check off, and then they'll have substance abuse information and then you can check off. If that's not checked off, then technically you cannot disclose anything related to their addiction and or addiction history. And we want to be able to, especially if you're working with providers, we want to be able to have full disclosure to a certain degree, because ultimately we want to have a nice sort of care coordination plan for that person so that they benefit in the long run. Make sense? The only thing is that sometimes the providers get upset with us because we have to call back, we have to send them our release, so it holds up the process. One way that my counselors, when I first started in the field and worked as a clinical director and a clinical supervisor, one of the things that we did was I just said, listen, just start writing the names of all the people that we work with in the community, and let's have one day where we go around, introduce ourselves, we give them our release, we make it easy and say, hey, if you have anybody that comes to our facility, you can already have them sign this one, and then we're good. And they really appreciated that because it helped save time on their end, and it helped develop a better relationship, a better partnership. So disclosure means any communication of information about the identified patient. And records are any information acquired about a patient, including identity, address, medical, or treatment to, from program staff. Patient, any person who has applied for, participated in, or received an interview, counseling, and or other service. So something I'm thinking about right now that I did not do homework on, because again, this is a new program for me, in terms of understanding what your practice is. But one thing that I know for certain is that as a program, like the programs that I have always been involved in, we could never disclose third-party information. So for example, I've had quite a few clinics at one point working under me. So we provided the substance abuse treatment, and as a standard practice, we would get a release to their psychiatrist, for example. Psychiatrist would send us a list of those medications. Now we're working with a PCP. We can't release to the PCP the psychiatric medications, even though it's part of their medical record. So even though that doctor says, hey, they checked it off and said, I can have access to their medical record, that does not include third-party information. You cannot do that, okay? So gets a little, and so for you folks who are going to be coordinating a lot of different things, it's going to be interesting. I would say that you want to spend a thorough session or discussion with them, making sure that releases are signed appropriately so that that saves a lot of your time. Yes?
And a question for you, a possible example. If you've got somebody who needs a client who needs something to go from one collateral to another collateral, can we be in the middle and transmit that?
I don't know. I don't believe so. I think it has to be direct, because I know even for us, when we're setting up extensions for medications, we can, if we have a release, we can communicate, but that actual documentation has to go from the one facility directly to that other facility.
So we could not, in effect,
Correct.
be a
Because
fax
then,
service for that person.
correct, you would not be able to do that.
Okay.
And again, you're going to want to take some of these questions to, your program might develop policies or other practices, but in general, the scope of practice, you cannot release third-party information. Okay? Now, one of my clinics, for example, if a patient came in to do X, Y, and Z and said, hey, can you fax this out to my whatever, they could use our fax machine. That's different. We're not, that's not our cover letter, that's not us doing anything, but we could not be that intermediate. Any person, 42 CFR applies to any person who has applied, participated, or received an interview. So sometimes people get confused because they think if we haven't hit an admit button or, completed the intake, that this doesn't apply to them. It applies to them. It applies to them. It applies to every single person, regardless if they've actually already participated in the treatment and have been fully admitted into the program. Oops. So communicating with a consent, a proper consent form can authorize all relevant parties to share information necessary to coordinate services and monitor the case. Consent forms must be drafted carefully to maximize their usefulness and avoid unnecessary communication and hurdles down the line. Have folks here had some experience in securing releases of information? Yes? Hands up if you have. Woohoo! Hands up if you haven't. Never secured a release of information. Okay, that's okay. So, what is the biggest challenge with securing an appropriate release of information? Because as someone who audits charts on a regular basis, it's always an issue. What makes the task difficult?
Getting it back in time.
Getting it back in time. So sometimes you might give it to the person, so they're not necessarily completing it with you, and the way that they're completing it doesn't meet the criteria. So now we got to go back. So getting it back in time. What else? Yes.
Getting a signature.
Getting the signature. Oh, so getting them to come in and actually sign the release. Yes. So if you're not in a place where they're coming in for regular standing appointments, absolutely, that's going to be a challenge.
The clarity of the form.
The clarity of the form. Now, what do you mean by that? That's a good.
Well, some forms are very specific only to one provider, and then you have the forms that you can do multiple providers, and then you have forms that some providers will not accept. So
I know. It makes so jobs
there's
so
not
difficult.
one general form that everybody could use, so
Right.
sometimes, like, for example, like I'll send a form from my side, from High Point side to a PCP and they say, no, we cannot accept your form. I don't know if because their regulations are different and maybe we're missing something in our form, they have to sign our specific form.
So the only time that I've heard of that is if in fact 42 CFR is missing. So there have been times, for example, where someone will send us something and something's not indicated related to substance use. When it comes to High Point, we have a blank, clear form that you can put anyone's name in, and then we have this other one that has like 3 different, and that one is a little problematic for some of the programs. I prefer using one of them for each person. Yes.
I think a lot of providers will oftentimes require that you use their form, and I think it's to protect themselves because their lawyers have already reviewed that form and approved it for the use, and they don't want to have to be presenting your form to their lawyers, so they will insist that you use theirs.
That is another reason. And unfortunately, what people don't understand is that the law can be laws are meant to be interpreted and misinterpreted. And so no matter what, if you are a provider, folks have always said this to me in supervision and whatnot, at the end of the day, there's going to be times in your profession when you're going to make a decision and you're going to question whether or not it's a violation of HIPAA and or 42 CFR. But at the end of the day, you have to have sound clinical reasoning for the decision that you're making, because someone can always make an argument that it should have been something different. So these are guidelines, right? And then how we apply those guidelines can sometimes depend on the place that you work, what they think should happen, what their attorney says is okay. And so I don't want people to get boggled down with it, but what I do want you to know is it's a challenge. It's a challenge because sometimes they're not completed accurately, which is the bigger concern. If you don't fill in all the pieces, if you rush it, right, that's when it becomes an issue. And that's when the form already starts, the problem already starts there. If you have a form that's completed the way it's supposed to be, that's like half the battle, right? Then documenting disclosures is the next one. So a program covered by Part 2 may not disclose information that identifies a patient directly or indirectly as having a current or past drug alcohol problem or as a participant in a Part 2 program unless the patient consents in writing. And so, being that my predominant experience has been in substance abuse treatment settings, it has to be specific. They can't just say any and all information. Unless you want to risk having someone file a complaint against you, you're going to make sure it's detailed. So when I used to have folks that wanted to have somebody's substance abuse history, I would always call that place, right, as a courtesy, and say, what is it that you're looking for that will help you in the treatment planning of this patient? Are you looking for the last year, the last 6 months, the last 30 days? Because there were some folks that we worked with for 5 and 6 years. Why would someone need 5 and 6 years of their medical history and drug screens? That's not necessary. They might not even really benefit from getting their bio because that was 6 years ago. They're completely different now. So you want to try to, instead of pushing it back on the patient or the client and saying, you go and ask them, just pick up the phone and ask the provider what they're looking for. And then that way you have a clear understanding of what it is that's going to help with the treatment planning of this person, and you do the release accordingly. And most of the time when it has to do with substance abuse information, you always want to check off other, and you want to be very specific with what it is that the person is asking to disclose. The last 6 months of treatment compliance, the last 6 months of drug screens, the last 6 months of medications, whatever the case may be.
And just to interject, everyone should have a copy of the ROI that we'll be using for the CCN. It was in the purple folder that we went over earlier this week. So I don't know if you want to
Great, can I take a look at it? That would have been helpful for this training. Thank you. Initial, substance abuse disorder information and 42 CFR is there, handy dandy. Signature of person served. Interesting.
All agencies.
So, other information not specified above to be disclosed publicly for the purposes of care coordination. it doesn't, this is interesting, because it doesn't really allow to specify what it is. It's sort of just saying, yes, you can disclose my substance abuse history, so that's interesting.
Yeah, the first page.
Ah, thank you. See, you guys are on top of it. There you go. And there's the other box. Yeah, that's the box I was looking for. So that's an important box, because a substance abuse history for somebody could be something that's lasted 10 years. Do I really need to hash out what happened to you in the last 10 years of your life? No. Considering that most people, if they knew the whole history, would have a bias towards that person. Most people. So, all right. What are we doing for time? 12:55. We're moving right along. Who is protected? Anyone applying, anyone admitted in treatment, and anyone who's been discharged. That's pretty self-explanatory. A disclosure, communication of records containing information. This is whether it's in writing, orally, or electronically. So are you folks going to be documenting your interactions electronically in an EMR? Yes? So here's another area of standard errors with compliance. Clinicians, case managers, nurses do not document disclosures appropriately. It happens all the time. So back when we were Paperland, this was not as much of an issue. So I don't know how many of you were in Paperland long time ago. Since 2005 I've been with an EMR, so it's been a while. But we literally would go into a medical record, and on the back of the chart was sort of a log. And anytime we made a disclosure, the releases were also in that section, so we could verify if there was a paper release, and then we would put the date and briefly what the disclosure was and who it was, and we would initial it. Easy. So depending on your EMR and how user-friendly it is, you're gonna have to go and search where you document that disclosure. So just make sure you don't have to write a lot of information in disclosures, but you just the extent of what it is. So the purpose was care coordination, history of medications. Here are the exceptions. When do I not need a release? When I have a patient consent. Internal communications. So this is the question that I didn't get the answer to here, because from my understanding, there are a few different spokes in this wheel of the work that you're going to be doing. So I would definitely ask your directors or your supervisors, who is included in this internal communication? Do you have an answer? Are you a director?
I am. I believe it's the CCN network.
So it's okay.
Because we'll be getting names from Mass Health, and High Point will then be giving to the rest of us.
I see. Okay.
But it is a good question of within your program internally, can you share it with another level of care without getting any?
And that's something I think we need to look at. So whoever your supervisors are, and I don't know who those folks are for High Point, but we want to make sure that you have a clear understanding of who's covered under internal communications. Medical emergency, clearly, if there's something, you have to call an ambulance or something's going on, you do not need that. But interestingly enough, and I just did 4 of these, 3 or 4 of these on my campus to make sure everybody was up to date with their HIPAA training. And what I realized was that people did not consider or think about, what about when I call a non-emergency transport? You need a release. It's not an emergency. And sometimes we may call a non-emergency transport to a hospital because someone is voluntarily asking to be seen, that they need to go to a hospital. And so it's something to think about. Audit or evaluation, so if MBHP comes down, Beacon comes down, we do not need a release for them to audit charts, because they're doing it with the intent to make sure that we are not being fraudulent and that what we say we're doing and what we're billing out for is exactly what we're doing. Crime at a program or a crime in progress, but even so, it's important that you know that if it's a program that's federally funded that you can't disclose identifying, like you can't give the person's name. You can say what they looked like, what was happening, what direction they were running in, but you cannot disclose their name. And so that's sometimes the difficulty with, unless, and let me preface this, unless there is an exception, and I'm gonna have to get back to you because your affect changed and it made me think about it. But there is a time frame when they can, and I wanna get back to be clear of it. But most of the time, for example, when in my previous place of employment, if someone even left the facility and we were concerned that they were impaired and they took off in a car, we could not disclose. Our attorney at that facility said you cannot disclose their name. You can give the car, the make, the model, but you can't even say that they're coming from a substance abuse treatment program. The work that you folks are doing may be a little bit different, but if they're leaving a substance abuse treatment program, we cannot disclose that.
Do you think it would be different at like a community health center?
Might be.
Okay.
It might be.
Yeah. It's federally funded, but it's not just substance use.
It's abuse,
It's a
so it
lot
might
of other
be, yep,
things.
that's a good question.
I think it would be.
So here's what we want to do. We want to obtain consent at the earliest point. So at the earliest point of treatment, we want to obtain consents. And we want to make sure that whoever's obtaining the consent is comfortable having that conversation. That it's not just like, here you go, sign. But that we really engage with them so that they understand why it's important to have a release, how it can protect them, and also how it can help them. Because if we can't talk to your provider, right, and you're gonna find that folks who have mental health issues and substance abuse disorders, they don't trust many people. And so it's actually gonna be interesting because you folks are gonna be possibly meeting with someone once in 3 months. It's gonna be interesting what that dynamic's gonna be like. Because these individuals do not easily trust folks. And what you're gonna interpret as resistance is really just them being guarded. So I want you to be mindful of that. So, but you wanna try to obtain consent at the earliest possible point. What would that be for this program, I wonder?
As soon as you go out with them for that initial meeting.
That initial meeting? Okay. Identify all necessary parties. So you could, wow, so that first initial meeting, I just want to backtrack for a second. So the first time that you meet with them, you're going to basically explain who you are.
And sign consent.
What's that?
Sign program admission, basically paperwork, and then consent.
Paperwork and then consents.
Yeah.
So meaning that they're accepting in the
whatever's-
program. Once
yeah.
they accept it, then consents.
Yeah, so whatever's like, and immediate, like if, like emergency contacts, doctors, whoever you're
Emergency
gonna,
contacts,
whoever you're gonna
doctors.
initially like need to contact, and then down the road as things come up, you would
Okay.
get releases when
Get
you need
releases.
them, but initially it's usually like providers, emergency contacts, disclosure statuses if they have a medical condition that you're gonna need to talk to the doctor about, those things.
You're going to identify all the necessary parties. You're going to define the information to be shared. And what I saw in that release, especially when I turned the other side, I was like, okay, it's comprehensive. I was concerned when I saw the first page. I was like, that's it? Okay. The duration of the consent, which most programs have standard policies. I believe ours is 1 year.
Yep.
This just, again, this is really more of a resource tool for you. It just tells you step by step. Especially if it's the first time that you're doing one, this will be a great sort of like how-to to make sure you dot all your I's and cross your T's. So here's something that I add that most folks, I had a doctor that I worked for in one of my programs who I absolutely loved. When he left to go to Vermont, I was so upset. I'm like, why are you leaving us? Just one of those doctors that you really enjoyed working with, and he did a great job coordinating care with counselors and the clinical team. But one of the things that we were really concerned about is that patients sometimes who struggle with mental health and or addiction will present impaired occasionally, right? Is that safe to say? Mm-hmm. Or maybe they even sound impaired, right? And the way that they sounded the other day is definitely not the way that they sound today. And it leaves us concerned. We're not saying they got high, but there's definitely an impairment that we are able to pick up on. And what we found was that staff were very hesitant to call an emergency contact, even though the person was impaired. And there was this whole, discussion and debate, clinical discussion and debate. Well, we don't want the patient to then not trust us, and we don't want the family to think that they were hot. There was all this discussion. And so what we started to do at this program with this doctor's suggestion, which I loved, is when we met with them for an emergency contact, we were very open and transparent and said something to this effect. We know that you're struggling with mental health and or an addiction, and that sometimes you may engage in behaviors or make a decision that could put you at risk. Our biggest concern is your safety. So if we see you or hear you sound in a way where you might not be in the right space, we want someone that we can call to check up on you. Because if we don't have someone, then our alternative is to call the police for safety check. And again, not because we want to hurt you, but because we want to make sure that you're okay. 90% of the time, when you present it that way, they're going to give you the name of someone that if they were impaired, they don't mind you calling them. And I like that idea. Because you're not, maybe if I call a police officer, maybe you're lucky and you're going to get somebody who's understanding and will do a safety check and it'll be a good experience. Maybe not. But if you can identify someone that you trust. So when we would present it this way, a lot of the emergency contacts went from being mom and dad to like a girlfriend or a boyfriend, which I didn't mind as long as I had somebody I could call to say, I'm concerned, they didn't sound right, they could barely finish a sentence, they were answering things that I wasn't asking them about. That's important. Because my guess is if you're doing any phone contact with them, that hopefully your company or your program is going to have policies in place for what do you do when you're managing an impaired patient, or if you're talking to someone on the phone and they appear impaired. You hang up that phone and you don't talk to a supervisor or make a clinical decision about somebody like that, and something happens to them, you have some level of responsibility, right? So it's important for us to keep that in mind. So I just do this.
Question.
Yes.
If we do wind up calling the police for something like that, do we have to document it in some special way, fill out special forms?
Well, you always want to review it with your supervisor first.
Okay.
So I would definitely review it with your supervisor, and depending on the company that you work for, there may be an incident report or something that you have to fill out explaining why you made that breach.
Do we then have to get feedback from the police?
I don't believe so. I believe our responsibility ends once we report to the police for a safety check. Because then it's their responsibility to. You can. I mean, in the previous place that I worked at, oftentimes they would call us back. But you can definitely ask them to give you a call back.
We have the critical incidents and grievance reports we'll have to fill out for our program too.
So internal communications, we've already kind of spent some time talking about this. I don't want to rehash this in a lot of detail. I think the biggest thing is figuring out who does that encompass, because I think that was a good point that someone brought out. Qualified service agreements. So there's sometimes organizations that you have qualified service agreements with, and if you have those in place, then you do not need a release. That's one of the exceptions. Medical emergency we talked about, audit and evaluation we talked about, crime and location. Suspected child abuse or neglect. So one of the things, and I did not include it in the packet, but I most certainly can have it forwarded to you, regardless of what your organization may require, this is just my own suggestion to anybody, whoever may be in a position where they have to file a 51A. I have always required that, let me see if I can pull it up for you. How do I escape? Escape? So what I typically do is I make sure that all of my clinicians, all of my staff really, have the actual paper form on when you file a 51A. And the reason I like this is because before you make that call, I have always required my staff to write it first. Because you want to make sure that what you're reporting is specific to what your concern is. And that is what the law allows you to do. Anything else related to that person's history, their treatment, what you know about their past. That's not what the 51A is. The 51A is on the specific incident that you feel poses a risk. So what this helps you do, because what happens when you file is when you call, they may ask additional questions. And if they do, it can sometimes throw somebody off, especially if it's your first time. So you document it, you make the call, we'll always consult with a supervisor first. Quickly document it, you make the call. If you're doing it for the first time, I would always recommend making that call with a supervisor so that you have the ability to kind of, it's a skill that you develop. I remember back when I haven't had to file many, but in having to file them, having then them ask questions that they're not supposed to ask, that aren't relevant to that. And if you're not seasoned and you're not experienced, you don't want to come off seeming like you're don't want to be helpful, but we have to stick to just what the actual incident was that put the child at risk. So if folks want to, can we figure out a way that we can have this forwarded to people if they want it, Jess?
The presentation, if you want to send it to me, I can print it out for them.
Okay.
Form.
Just the form, just the DCF form that I have.
Can you email it to me? I can
Yeah, I
print that
can.
out to them.
Sure. Will
We
do.
have everybody's emails set up yet, but I can at least print it out for them and bring it on Monday.
Okay, wonderful. All right, now where was I? PowerPoint. Yep. From the current slide. Court order. So lucky for you folks, you probably won't have to really deal with this personally. Sometimes counselors do because they'll get the phone calls. But more than likely, it will be someone responsible for medical records that gets this order. But the interesting thing is that for a program that's federally assisted, so any kind of substance abuse program, it has to be a specific type of court order. So sometimes we'll get court orders that would work, and we would have to relinquish that information. Let's say if we worked in an outpatient mental health program, but in a substance abuse treatment facility, it won't work. So typically what most programs have is they have a standard letter that's generated by their attorneys that we send out to whoever it is that's sending that initial court order, and most of the time it's coming from family and probate court, saying that based on the person's treatment and that they're in a program protected by 42 CFR, that we cannot disclose the record without a consent or release. And then most of the time what we would do is meet with the patient and say, listen, this is what they're looking for. If you don't sign a release, this is potentially what could happen. If we get subpoenaed to court and a court orders you to disclose, then you can't refuse. But up until then, without the appropriate order, we can't relinquish the record. So it's always a benefit to the patient, client, to sign a release. That way they can select what it is that they're okay with going. You know, okay, I'm okay with my treatment for the last 6 months to go over. Okay. So for those folks that are high point, these are some of the policies that we have that can really help you. There's individual rights to their record. So if they request a copy of their record, you know, what do? And there's a form that they fill out attached to it. When you're faxing information, we have a specific release to that with an updated cover sheet, so you might want to take a look at that. Reporting abuse or neglect, restraining orders, which you folks probably won't ever be in the position of having to deal with, and then the duty to warn. So those are policies that you should definitely become familiar with. And so sometimes I'll see some initial pushback when patients request their record. I don't know if you've ever seen that, but sometimes I'll see folks get really nervous about that. They have a right to look at their record. So all they have to do is just fill out, depending on where you work and what your organization, but there's usually some kind of process, but they do have a right to their record. I'm assuming that most of you have had some provider at some point, you want your record, right? Okay. And so addressing phone calls, so this will be interesting because you folks are going to be having a lot of phone communication. So just some basic rules of thumb. If it's your first time accepting a call from someone, if you have no way of clearly identifying the number, you may ask them for their name and their number and call them back at that number. That's the safest bet. Once you obviously have developed a relationship with someone and you don't obviously have to keep doing that all the time. But I typically will do that, especially if it's family, folks saying that they're family, before I even kind of, okay, can you give me a phone number I can reach you at? And then I call them back. Providers, sometimes I've had calls where it's actually people in their lives that are saying that they're the PCP's office or somebody else. So it's really important that you initially ask for that number and call. Oh, goodness. Visitors to the program, I don't think that's something that you folks would have to deal with. And social media, it goes without saying, you really don't want to post anything about what you do for work. So I personally just refrain from that whole thing. But I have seen some pretty interesting things in my history, and hopefully folks just know that whether it's a bad day or whatever, anything that you post that could potentially identify an experience that someone had, it's a risk of a HIPAA violation. So, okay? So we'll take a break, Jess? Yes? And then, yes, so you have a question, I'm sorry.
Yeah, because I hear a lot of conflicting information about this one.
About?
I've always gone by, if a client leaves the program, that release then becomes null and void.
So most programs, and it depends on your company's policy, but most programs, releases are still valid for 30 days post-discharge, if that's the way that they signed it. Other folks, so it really depends on it. So my previous company, it was automatically 30 days after discharge.
Does it have to state
And
that in the
it said
release?
that.
Okay.
It actually said that. And the reason we did that is because sometimes somebody might leave abruptly, but we're still coordinating care. So that might be something to think about. I don't know what the clear policy is for this program that you're involved in, but you may want to consider talking to the individuals that have structured the program. It may make sense to have, up to 30 days post-discharge because, again, someone might abruptly leave treatment and then all of a sudden somebody's calling because they showed up somewhere and you're trying to coordinate the care. Now we got to get the releases done all over again.
So, just for my own clarification, legally, without that statement,
It's discharged,
they
correct.
are null and void
Correct.
once discharged.
Unless it says it within a release of information,
Okay.
there's no standard guideline in confidentiality laws that says it's good for 30 days post-discharge.
Right.
You have to have something in place as a company that says that. And they need to be notified of that. So we had to note, in my previous place, we had to notify folks that for 30 days.
Yeah.
And they actually liked that because sometimes they were going to other places and this way it wasn't a hassle to get their information so they could continue care somewhere else.
I actually like that, and that's useful.
So, I mean, it's something to think about. Okay? All right, we'll be back in about 15 minutes. We're moving right along. 118. Right?
Yep, bomb.
This is my third presentation of this.